Greetings, class. I just wanted to talk a little bit about the introductory information on international law. There are several issues that you should think about if you're involved in or engaged in international business. And this is just sort of a broad overview before I talk in more detail about the information that's in the chapter. The first issue that I wanted to address is the issue of communication and cultural differences. And you'll see on the slide I actually have some fabric that's different styles, different information on the fabric. There are things like, for example, there are beads. There are different textures of fabric, different linings. It looks like there are wooden beads in it. And everyone interprets the fabric differently. And so in terms of communication, what we have is figuring out how to, or being aware that there are different perspectives in how information, how the negotiations, how conversations are interpreted. And although this doesn't directly relate to fabric, an example is in the meaning of a contract. In the US, we tend to be very legalistic about it. That is, that you've signed this contract, it has certain terms, you must fulfill those terms. If you do not, then you're in breach of the contract. Whereas if you go to other countries, you will see a different interpretation. If you take, for example, I'll just say an Arabic country, where the price of something is not necessarily the actual price, it is the point at which you begin negotiating. And it's expected that when that price is listed on an item, that is just where you start. Whereas in the US, when you see that price is the contract price that if you buy that item, that's what you have to pay. That also relates to cultural differences as well, that how we interpret contracts, how we engage in business, how we build relationships among business partners can differ a great deal. So though this isn't a course in communication per se and cultural differences, as you're looking at the international legal issues, you have to be aware of the cultural issues as well. And one point I forgot to mention in talking about communication is, of course, the language issue. Just the fact that we're communicating in different languages, although English has increasingly become common language that's used in business internationally, it is not the only language. And even then, cultural differences can color how that communication proceeds. There can also be differences in the political climate depending on the country. So what I have on the slide is a map, and it's mostly European countries, but that there can be differences in how the law is even interpreted. One example is the difference between a civil code country versus a common law country. The US is based on the common law, and that's the English law. You can see at the top of this slide, there's England in the green. And the English common law is based on the idea that once the judge makes a decision in a certain area, then other judges can use that for guidance. It's all based on like precedent. Whereas civil code countries are different. Each judge takes what the code is, what the law is, and interprets it, but doesn't necessarily look to see how another judge may have interpreted it in the same situation. So the result can be dependent on that particular judge. And there are advantages and disadvantages of each approach. But if you're talking about doing business internationally, you think, well, okay, I can look at the common law, or I can look at what a judge decided in one case, and that can be guidance. You just have to realize that there's a different approach. If the country is a civil code country, such as France, versus and France is here in, I don't know what you would call that color, brownish pink. So that's France versus the common law countries. So you just need to be aware of the differences. And then a second difference is the difference between expropriation and confiscation. Expropriation and confiscation both apply to when a government takes private property. Expropriation is more generally accepted in international law. Confiscation isn't. But each country has the right to decide what that country will do with property that's located in that country. So if a country takes private property for public use and compensates, that's expropriation, and that's very similar to eminent domain in the US, where the government says, okay, we need a road or we need to nationalize this industry, and if your business happens to be in that industry, then your business would be nationalized, but there would be compensation for it. Now, you may argue about the amount of the compensation, whether you think it's adequate or not, but in general, there is some compensation for the national government taking your private property. On the other hand, with confiscation, the national government decides to take that property, does not compensate or compensates so minimally that it's in effect no compensation. And in terms of international law, as I said before, confiscation is more a violation of international law practices, whereas expropriation is consistent with international law practices. So expropriation is more similar to eminent domain. And then the last concept that relates to the political climate is extraterritoriality. And that's the idea that in the US, certain US businesses are bound to US law even when they go outside of the country. And there are several different laws that US companies are bound to. For example, the Foreign Corrupt Practices Act. And that's an act which distinguishes between what's a bribe and what's a grease payment. So that's discussed more in more detail in your book, but I just wanted to give you a sense of how that relates to overall international law and international practices. And then the last thing that I wanted to mention just as an overall issue is how you get paid and how you make sure someone performs the contract in the international context. Now here on the slide, I've just given you from the European Union public authorities and how frequently or how long it takes for them to pay off accounts. And different countries have different issues with payment. If you look at the Burgundy, is greater than 69 days delay in payments by the Spanish and the French authorities. So if you look at the very bottom of the slide, that's where those countries are. But the idea is that, of course, when you have a contract with someone, you want to be sure that you get paid, and you also want to be sure they perform. Letters of credit are one way to ensure payment. I'm not going to get into that into detail now, but just to give you an overview that that's the issue that's involved is if you're shipping goods to another country, to a company in another country, you want to be sure you get paid. Or if they are shipping, you're paying for goods that are to be shipped to you, you want to be sure that the goods that are shipped are of the quality and quantity that you had contracted. And that's part of the full faith and credit that if you get a judgment, for example, against a company in another country, that the other country's government will comply with that. So that's the basic overview, and I will see you online.